Hi everyone, Judicial Watch President Tom Fitton here with a special update on the Clinton email controversy. Judicial Watch will be deposing Mrs. Clinton under oath in a key Judicial Watch Freedom of Information Act lawsuit. And here to talk about this major development is our senior Judicial Watch attorney, Ramona Kotka. Ramona, thanks for joining us.
Thanks for having me.
Now, Ramona, in this case, this has been your case for almost 6 years now. And, I was thinking about and thinking about what we're going to talk about. I go back to 2014 where we were talking about in the office that, well, we had all this Benghazi material on Hillary Clinton and what was going on in the State Department, but we didn't find any emails.
Right.
So we asked and had to sue.
Well, right. When we were talking, we're like, where are Hillary's emails about the Benghazi talking points or anything related to Benghazi?
So we filed a lawsuit for it and describe how it is we kind of forced out the emails as a result of that.
Oh, sure. So we filed it's our second talking points case. And this was specific for email records and communication records from Secretary Clinton's office about the talking points that were provided to Susan Rice about the Benghazi attacks. The State Department didn't respond to our initial FOIA lawsuit, so FOIA request, so then we had to file the lawsuit. Once we filed the lawsuit, in or around...
Again, this is in 2014.
In 2014. In or around September, and the timeline is important here, in or around September of 2014, State Department tells us we're conducting the search, we should have it completed to you by November. And in November, we hear from the State Department and they tell us that they've located 4 responsive documents, 4, all of which were already previously produced to us in our initial talking points case that we had requested records from Ambassador Susan Rice's office. And that's when you and I were talking and we were looking at these 4 documents and we were perplexed that these are the only documents that the State Department had uncovered. And on December 5th, the same day that Secretary Clinton returned those 12 banker boxes with her emails is when the State Department provided to us an explanation of information that they withheld under certain exemptions under the Freedom of Information Act, like deliberate process or classified information, that sort of thing. And we weren't satisfied, so we went back to the State Department and we said, what did you search? Because we were questioning their search at that point. And by December 5th, State Department told us they were in custody of the 12 banker boxes, and they told us, we've searched all the records, potentially responsive records, and these are the only documents that we found.
And we should shut the case down.
Correct. The purpose for providing the explanation is called a draft Vaughn Index, and that's for purposes of settling the case, saying, look, the agency's done everything it's supposed to do. Let's settle the case now. Yes, by February they told us we have to do another search by January. And then in February they said they would complete that search in April. And March is when the New York Times piece came out about Secretary Clinton's emails and her email use at the State Department.
So there was a separate case where we were granted discovery. We would ask for Yuma Abedin, top AIDS emails or something related to her employment. She got a sweetheart job at the State Department. She got to work for the Clinton Foundation and the State Department at the same time, which was odd. So the judge in that case, Judge Sullivan, had granted us discovery in 2016. So all of these Clinton people were coming in and testifying to you and your attorney colleagues here at Judicial Watch. But this case, this Benghazi case, the judge had held up on authorizing discovery until December of around late 2018, right?
2018. So Judge Lamberth, in this case, he granted us discovery. So back in 2016, he ruled in our favor that because the State Department had filed their motion asking for the court to dismiss the case. And Judge Lamberth ruled in our favor. However, he held off on giving us the green light to move forward.
Oh, so in 2006, now let's be clear here. 2016, the Obama administration wanted to shut down the case. And then, you know, things moved along, and we kind of pushed again with Judge Lamberth for discovery, for him to begin authorizing, you know, to allow us to conduct the actual discovery. What was the position of the new administration? President Trump may want to close his ears for this when he finds out what his Justice Department and State Department were doing.
Well, I mean, the new administration's position was exactly like the previous administration. There's nothing here. You've already received all the information you wanted to. All your questions have been answered from the previous discovery, and there shouldn't be any more discovery.
So the judge said, no, that's ridiculous.
Right. I mean, Judge Lamberth said there are more questions than answers.
And he was angry at this Justice Department and this State Department for misleading him.
Yeah, I mean, this case goes to the question of bad faith, and that's the reason that he initially opened discovery.
So bad faith is, you know, it's one thing to argue with the government, hey, you didn't look there, you didn't look there, and you get into an argument. It's another thing for the government to know there's something there. Right. They know there's this file, and they're not going to look into it because they know what's over there, meaning Clinton's emails. And so that's the issue of bad faith. They knew about the Clinton emails and purposely didn't tell us because they were in cover-up mode.
Well, that, and because we were granted and permitted to have the discovery in our case, we did actually find out in this case, and this is the reason I was saying the timeline's important. Back in September of 14, when the State Department told us that they're conducting the search, now we've uncovered, they located an email from Secretary Clinton that related to the Benghazi talking points, and it's clearly relating to the, I mean, the entire substance of that email is about the Benghazi talking points, and they deemed it that it wasn't responsive to our case.
And when did they finally give us that email? Or the full version of that email?
They gave us the undisclosed version of that only because we asked Judge Lamberth for it, and he granted it.
They were forced to.
They were forced to, and even after Judge Lamberth granted our request, they still protested, and we threatened to go back to the court to be able to get this, and I believe they disclosed it in either September or October of this past year, in 2019.
2019,
fall of 2019.
Over 5 years after they found it.
Yes, yes.
So that goes to the heart of Judge Lamberth's major discovery ruling in 2018, where he said, Judicial Watch, I want you to investigate the following. Right. Whether Mrs. Clinton used this system to avoid the FOIA, the Freedom of Information Act, whether they were acting and messing with the court and misleading the court and trying to shut our case down improperly without telling the court about these emails. Right. Whether there are other emails to be found, because this is a FOIA case. Right. And I thought it was interesting also, he also added on, he said, I want to know if they were concerned about Benghazi. And that's one of the reasons they didn't want us to look in the emails, because they were worried what might be in there. Right.
Right. So Judge Lamberth wants to know if there was a nexus between specifically Benghazi and Secretary Clinton's emails, for that being the reason for the State Department not disclosing the fact that she used email.
So we got some documents, discovery, but we also got witnesses coming in as a result of that. So there were at least, what, 19 witnesses by my count around that?
You know, I haven't counted recently, but there were, yes.
Nearly 20.
Yes, yes.
And so they came in and testified, and you and your colleague Lauren Burke and other lawyers have been working hard over the last year compiling more discovery pursuant to the court's inquiry here. Because, you know, we're acting in many ways, I kind of see it as an agent of the court. The court wants this information so he can decide what to do.
Right.
So what, you know, this, now we haven't gotten Mrs. Clinton to testify yet at this point. So what sort of information were we getting that you thought would be, it's important for our listeners or viewers to see in terms of setting us up for this next major development? So
for the discovery up to this point, the crucial information that we really found out is, first of all, the office that was providing the security to and the technology services to Secretary Clinton's office.
The help desk.
Yes,
what I call it.
It's the help desk, but it's the help desk that's dedicated just to her office. So they have often interactions with the Secretary's office. That office, in the most recent testimonies that we received, we've learned that They were informed about Secretary Clinton's emails, email use very soon after she started at the State Department, and that they had to know that information to do their jobs. And the other piece of it as well, and goes specific to the State Department and what the State Department officials knew and when they knew it. The other piece of it is the FOIA officials, the Freedom of Information Act officials at the State Department, and when they interacted with the IT office for Secretary Clinton's office and what they were told. And that's part of the reason that Judge Lamberth provided us the opportunity to depose two. One is a former official, and I believe one is still an employee, the director actually of the office, those two individuals to be deposed.
So these are names that people won't know or hear of or probably even recognize in the future. But they're important witnesses. So Mrs. Clinton is going to be deposed, and we'll talk about that further. But to start off, there are two witnesses who, knew or should have known at the time about her emails, and then subsequent about what her email practices were.
Right, and we know that those two individuals interacted with at least one FOIA official who we deposed, Tasha Tian, in the last round of discovery, and she was basically the archivist for the State Department. And then we also know that they also interacted, the director, Brett Gittleson, with the attorneys at the State Department who were handling the FOIA cases, including, going back to 2013.
Did the FBI interview these people?
We don't know. That's something we'll ask them.
Have you seen any evidence they did?
I do not know. A lot of...
you've looked at what the FBI has produced publicly in terms of what their
correct
investigation, and you haven't seen these folks have been interviewed.
I have not seen that they've been interviewed. Now, many officials' names are redacted from the FBI.
So it's maybe
302s, but so far we haven't seen anything to indicate that they have. But
so
we'll
another interesting thing of the discovery is what Mrs. Clinton and her top people were warned about in terms of email use. We had some pretty dramatic revelations in that regard, haven't we?
Yes, that's Ambassador Boswell's testimony, who we were able to obtain. And she was warned, I believe, in person as well, where she acknowledged that she understood the warnings about using her BlackBerry, which we know very well she used readily for State Department business. And I believe she was warned 3 times, at least 3 times.
Personally?
Yes.
And it's like a half a dozen times if you include her top staff.
Oh, correct.
Yeah, it would probably be more than that.
Correct.
Yeah.
Yeah.
And so, look, it's not easy to bring in, even if Mrs. Clinton's been out of office since when, 2012? It's not easy to bring in, to convince the court to bring in a former senior official to testify under oath in the Freedom of Information Act case. What was it that Judge Lamberth what is it that you had to show to court in order to persuade the court? What standards did you have to kind of meet in order to persuade the court to allow us to depose Mrs. Clinton?
I think the reason that we're here today is because the State Department has continued to do what it was doing back when Secretary Clinton was still in office. And it's to obstruct the information and to actually come out. Had the State Department come out and said, this is what happened, we're coming clean, I'm not sure we'd be here today. But every single time we've been before Judge Lamberth, there's new information that's become available and more questions being raised. So for the last time that we were in front of Judge Lamberth, we had just found out that 30 additional emails, right, have been discovered or produced by the State Department, which we understand were forwarded from the FBI. And this was back in October, in or around October of 2019. The FBI did its investigation in 2015. That's 4 years later that we're still getting emails. So it's really the loss of confidence.
And they couldn't tell the judge where they came from. I was at that hearing in December. They couldn't tell the judge where it came from.
Correct.
Where they came from.
Correct.
So, but what is it that the court wants to hear before he brings in a senior person like Mrs. Clinton? There's language about the Apex Doctrine and how the apex doctrine basically is you've got to really have a good reason to bring in the head of an agency or even a former head of an agency to talk to them about what they were doing.
Absolutely, and you have to show that there's firsthand knowledge that because it's a cabinet level, it's a head of an agency official. You actually have, and because the questions here go to Secretary Clinton's state of mind and what she understood, not only about why she used the email, but Judge Lamberth wants to know what was her understanding about her record management responsibilities at the State Department. We have testimony in this case from Tasha Tian saying she provided training to at least, I believe she identified Huma Abedin at least in one of the trainings with respect to what they were permitted to do and what they were not permitted to do. But then not only upon coming to the State Department, but also leaving. And what was Secretary Clinton's understanding as to what she could take with her when she left the State Department? Because they have a form that they have to sign off if there are any personal papers, etc. But it has to be reviewed by State Department officials and signed off that they may take those. The one thing that's missing from that form is Secretary Clinton's email account at clintonemail.com.
And we now know that that account contained government and classified information.
Correct.
And why is it that it's important that Huma Abedin was warned and was trained on these issues?
Well, obviously, Huma Abedin was Secretary Clinton's Deputy Chief of Staff, and there was a responsibility for not only Secretary Clinton, but her entire staff to follow the protocol, but also to inform Secretary Clinton as to what her responsibilities and obligations were.
And Abedin had an email account on the server.
Well, that's the other thing. Yes, correct. Sorry, I forgot.
How quickly we forget.
Yes.
We've already deposed Huma Abedin, and
we have.
I guess we didn't have good reason to depose her again.
Not yet.
Yeah. There you go. That's what I like to hear. So the judge issued. So we're in court in December of last year. Because we've developed this evidence, you've developed this evidence, getting new documents, finding new emails, right. Getting testimony from nearly 20 witnesses.
Right.
And you had a strong argument to say, Mrs. Clinton, we finally got to hear from her. And her Chief of Staff, Cheryl Mills, who's instrumental in this system as well. Right. We got to talk to her again because we talked to her once before, but we've got new information. And, go back to that hearing. I mean, I'm there as not trying to make any trouble as the client, but you're there as the lawyer. I mean, 6 lawyers for the government came in, the Justice Department and State Department, on top of the 4 lawyers that Mrs. Clinton and Ms. Mills had. I mean, we had.
Well, we've gotten used to that.
I know, but look. I want taxpayers to know that the Justice Department and the State Department are still defending Hillary Clinton's misconduct. And they were in court a few months ago trying to stop us from asking her any questions or asking the agency at all about anything.
Right. So the thing about Judge Lamberth, we had asked...
Forgive me for getting outraged about that. I mean, but it's outrageous.
It is, but, the power's not in numbers. And the facts are just on our side in this case. Discovery is rare in Freedom of Information Act cases, but the evidence so far demonstrates there's real question about bad faith and also as to whether all of Secretary Clinton's emails have been searched to date. So that is why initially Judge Lamberth said, we'll give you discovery, but I'm going to hold off on determining whether Cheryl Mills or Secretary Clinton should be deposed. And we've gone through 2 rounds of discovery. And because there's still all these questions, the new emails that were uncovered, the testimony from the last round of discovery about Secretary Clinton, the training that Secretary Clinton's staff received, especially also the departing procedures. It's just basically what I was talking about before they leave. Also, Judge Lamberth agreed with us. We have so much more information at this point. It wouldn't be fair to rely on the testimony from Cheryl Mills and the little information we had back in 2016 and not be permitted to ask her questions in this case. And Judge Lamberth, this is a thing he also highlighted in his written opinion, but I believe also at the hearing, is the reason we're here is because of the State Department's conduct. That's the reason we're here. That's, you know, and the court's interest in this is to rule out bad faith and misconduct by the State Department. And the court isn't convinced yet based on the information we have, and the information, frankly, I think is troubling, and it's pointing in the fact that there was misconduct and there was bad faith.
And it seems to be continuing.
Yes.
I mean, that's, you know, that's, I keep on, you know, Attorney General Barr, in my view, needs to pay attention to this, and Secretary Pompeo needs to pay attention to this. If I were the president, I encourage anyone within the sound of my voice to read this ruling. And, you know, there's a grave issue going on. The cover-up for Hillary Clinton is more than just, you know, protecting her personally. It's
right.
this misconduct within the agencies. You know,
right.
what struck me about your discovery, the Judicial Watch discovery, is that we caught the Obama White House counsel's office in the cover-up. That they had told the State Department, were instrumental in the State Department's initial response to another requester right. who was just going through and asking all agencies about alias accounts of cabinet officials, and specifically Hillary Clinton. And they got a no records response at the recommendation of the White House counsel's office. Oh, so the Obama White House directed a false response by the State Department about whether there were Hillary Clinton emails. We uncovered that.
Well, we did, and to your point, up until we had to go to Judge Lamberth to request that information, they redacted certain information in those emails that hid the fact that the White House was involved. Now, I don't know if you remember, Tom, when we got those records. Initially, the subject line was redacted under deliberative process exemption. And we fought back and we said, deliberative process in a subject line? What? It was a redaction and Clinton's emails. So we specifically wanted, it's a small redaction, it would appear insignificant. We found out under that redaction it was WH standing for the White House. WH and Clinton's emails, that was the subject line.
So if you want to know why Hillary Clinton wasn't prosecuted, it was because the Obama White House would have been caught up in the prosecution. And I've always believed that if Hillary Clinton never had to go to court in terms of being prosecuted on any of these issues, the first person she'd call in her defense would be Barack Obama. I mean, I say that half jokingly, but you know, the Obama White House was involved in the cover-up. There's no doubt about it, because we've got the documents. And what else is interesting is, and we kind of referred to this earlier in the discussion, virtually everyone who needed to know in the State Department did know that she had emails, but they weren't telling anyone on the outside about it, and they were covering it all up. And the judge focused in on that like a laser.
Right, right. And again, that's in an email that we recovered in this case in the last round, in which somebody had disclosed within the State Department, I believe it was in the public affairs, the press office at the State Department, wrote an email forwarding Secretary Clinton's email address. And then there was a discussion about, oh, be careful, I know she guards it closely. So it's obvious that that would raise questions with respect to if Secretary Clinton is using that email for State Department business, why does she not? Why do they have to be careful to know that that's what she's using for State Department business? So and in particular, FOIA officials, right?
So we get all this information showing other additional misconduct, or even the depth of the misconduct, and the State Department, Justice Department still don't think there's any answers to be found further. And what did the judge think of that?
That's been their MO.
Yeah.
The judge doesn't buy it. The judge doesn't believe it. He thinks, obviously, there are questions, and he honed in on, there are questions that we need to ask Secretary Clinton herself. What was her understanding of her records management responsibilities and obligations? She was the head of the agency. These go direct. Our request goes directly to her records. Yeah, she's the only, and when I'm sorry to cut you off, but in the other case, when we deposed Huma Abedin, When we asked her about Secretary Clinton's understanding, she said, you'd have to ask Secretary Clinton that.
Yeah, I mean, typically
So-
the head of an agency doesn't have to come in because you're asking them about what someone 2 levels down said.
Right.
And they're like, you know, look, you ask them, I'm running
Correct.
the agency, you just don't bring me in because you want to.
Right.
In this case, it's her email system.
It's her email system. It's the one she wanted to use. Did she want to use it knowing about her FOIA obligations and to avoid FOIA? But also, did she want to use it despite the procedures and the protocol at the State Department?
So Judge Lamberth issued his ruling last week authorizing the discovery, as you talked about. So
Yes.
we get to depose Mrs. Clinton on the topics that we talked about, and
Right.
something about, and it's this Benghazi case. So what's our questioning on Benghazi supposed to be about?
So it's with respect to any knowledge she has about Benghazi records. So also, who does she email with about Benghazi? You know, we can't get into the substantive actions of the State Department.
So we can't ask Mrs. Clinton that when the Defense Department offered you and Obama military assets to deploy immediately, why you didn't take them up on it, and why did people die as a result? So we can't ask them
We
questions
cannot
like
go
that.
into that. Correct. Correct.
But we can say what documents were created and get into
Right. Right.
Which is
because
good.
at this point, that's
Yeah.
right. There's no confidence by us or by the court that all of the records have been searched. The relevant records have been searched, and all of her emails have actually been located. And that's part of the reason into the other part of discovery we haven't gotten to yet. But
we'll put the
yes,
to Google.
yes.
So Cheryl Mills also is going to be questioned,
Correct.
and the same topic, the general areas of discovery as authorized by the court. Why did she use the system? You know, why?
Why did she use the system, but also with respect to this question about bad faith and the settlement conduct at the State Department, and that's because Ms. Mills was one of the attorneys acting on behalf of Secretary Clinton during the review process to determine what should be provided and what's a federal record and what isn't.
Okay, so let's go back.
Okay.
Cheryl Mills was Mrs. Clinton's chief of staff as Secretary of State.
Yes.
Mrs. Clinton retired.
Correct.
She started running for president, doing her other things, and Cheryl Mills became her personal attorney.
Yes.
And this email issue, someone figured out we got to get those emails back because Judicial Watch is asking for these documents under FOIA.
Right.
Congress is sniffing around because they've got the select committee,
Right.
which was set up thanks to our FOIA. And so Cheryl Mills becomes the central figure in handling and managing the email response from Mrs. Clinton.
Mm-hmm.
So we get to maybe ask some additional questions on that issue.
Yes, and let's not forget there are about 30,000 emails that were also deleted. And we didn't have that piece of information when we initially deposed Ms. Mills.
So we weren't able to get every witness we asked for, but the one witness we weren't able to get, there's a real interesting reason why we can't question him.
Yes, and I believe you're speaking about Paul Combetta, who was the IT official for Platte River Networks. Platte River Networks was the company that serviced her server or operated her server, Secretary Clinton's server, after she left the State Department. And Paul Combetta was also involved in the deletion of the 30,000 emails.
After a congressional subpoena was issued.
After the congressional, in or around March of 2015, I believe.
And there was a phone call too, wasn't there?
There was a conference call with Cheryl Mills as well as David Kendall, I believe. Either the day before or 2 days before, these 30,000 emails were deleted.
So he was given immunity, or at least a immunity deal of some type too,
He was
despite him destroying records?
He was giving some limited immunity. We don't know exactly what the immunity covers, but the reason we do have confirmation that he was given it is because in response to our request for his deposition, Judge Lamberth had told us this back in December when we were in front of him to reach out to Paul Combetta's attorney to find out whether he is intending or would intend to assert his Fifth Amendment rights during, to any of our questioning. And Mr. Combetta's attorney told us that he does intend to assert his Fifth Amendment, and we had to report that back to the court. And that's the reason, that's the only reason that Judge Lamberth denied our request for Mr. Gambetta, not because he doesn't have relevant information, because there's also another piece. The reason also the court was interested in Mr. Gambetta is because of, it looked like Mr. Gambetta had archived Secretary Clinton's emails at some point in 2013, 2014 timeframe, and on a Gmail account that he had created some time ago. And Judge Lamberth and we have questions with respect to what emails would still are still there or would still be recoverable from that account of Secretary Clinton. Specifically, we're just talking about Secretary Clinton's emails.
So we're not going to be able to question him in person under oath because
No.
he's asserting the Fifth Amendment.
Correct.
And the judge didn't want to say, you know, you're not going to bring witnesses and just have them sit there and assert the Fifth. It's
Right.
a waste of time.
Right.
But it's still kind of a big deal in the civil context to assert the Fifth Amendment, isn't it right?
Sure, it is a big deal. I mean, it's your
unlike-
right against self-incrimination, right?
But in the civil context, and you know, I ain't no lawyer, so feel free to correct me, but I've got this impression that, you know, in the criminal context, you can't hold it against someone if they assert the Fifth Amendment. But in the civil context, one, in certain circumstances, can draw adverse inferences from asserting the Fifth.
Yes, it all comes.
I don't know if that would work in this case, but it doesn't mean, asserting the Fifth doesn't necessarily rule out any conclusions from about the court making about what Gambetta was about to testify.
That is true.
Yeah.
It does not. It does not. But that is why Judge Lamberth also granted us this our request to subpoena Google. So we're not stopping.
Well, that's the other good news, right?
Right. So because Judge Lamberth is interested in this, and we are frankly interested in this, he granted us our request to subpoena Google directly for records that would show any of the emails or pertain to any of the emails or archiving of Secretary Clinton's emails on that particular Gmail account.
So the judge is thinking that maybe Hillary's emails might be on the Google system somewhere.
Could be, yeah.
So we got to issue a subpoena. So we
Right.
got now 4 new witnesses,
Yes.
a new subpoena,
Mm-hmm.
and what happens next? We got to figure out when we're going to depose these people?
Yes, so we are already speaking with the appropriate attorneys for each of them with respect to scheduling their depositions, and the subpoena is going out soon, and we have until May 16.
So I'm going to ask you some questions that I've been getting from you, and I see online the questions and the conclusions people are drawing about this process.
Okay.
So the first one is Mrs. Clinton's going to wiggle her way out of it, that she won't be deposed. So I guess technically she can appeal this and delay it, but tell us what the likelihood of that happening is.
I think the likelihood is very slim. I don't think she has good faith, argument. She can raise the apex doctrine, which her attorneys raised at...
Meaning that she's too important to testify.
She's a high-level official.
I
In
know.
other legal terms.
That's my less than charitable paraphrasing of the legal issue.
But she's a high-level...
It's supposed to impress everyone else,
Yes.
but I see the apex doctrine as there's a different rule for high-level government officials and a different rule for the rest of us. But go ahead.
Right. Sometimes, it's good to have some of that protection, right? Because you have high-level officials who need to make sure that, they keep doing what they're supposed to be doing, either with their agencies or wherever their position is. Now, Secretary Clinton has been out of office since February 1, I believe, 2013. That's 7 years ago that she's been out of office, public office, right? The other thing is that we talked about is also a lot of times the particular issue you are able to, that's in question, you're able to obtain the information from, other lower level officials, as we talked about. Here, this goes to the heart of what was her thinking, what does she understand the responsibilities were. I mean, she's relied so many times in answering questions, either just, you know, on her website when she was running, or, you know, in interviews, that she was just following, she understood that she was just following normal State Department procedure. To this day, she's never explained what she understood that to be. What was normal standard procedure at the State Department? How did she understand that that her email was being archived?
And the court, to be clear, the court said, I want that question answered.
Oh, absolutely. I believe Judge Lamberth has that question in his written opinion.
Yeah, he has a list of questions he wants answered.
Right.
So when people say, Judicial watch this, and you're going after Hillary Clinton and the emails, you know, this is the court wanting the answers. You know, we obviously put it before him, but he wants these answers.
Right.
So in theory, she can appeal. Highly unlikely she will, and even less likely it will win.
Correct. I was just about to say, I mean, I just don't see that being a winning argument at all.
So we have to get this discovery done by May 16th.
May 16th.
So Ramona, one of the biggest questions we get is whether the deposition of Mrs. Clinton is going to be publicly available in any way.
Okay.
What can you tell us about that?
Yeah, so the deposition transcript will most certainly be made public. As to whether there will be a video of that made public, I'm not sure yet, but the transcript, I expect that to be public.
So, you know, these are questions people are having. And so the other question is kind of a hard, it may be harder for you to answer. Now the judge, when Mrs. Clinton already did answer our questions under oath, but they were in writing. And the judge says, look, you know, they were really terribly helpful, and she failed to recall a lot of things. It doesn't mean that she was lying when she failed to recall. But, you know, a lot of people are saying, well, she just shows up and says, I don't remember, I don't remember, I don't remember. Can you explain what happens when a witness doesn't do that in a credible way? Or,
right.
You know?
I mean, first of all, you know, a lot of it will also, in civil discovery, it comes down to also credibility, right? So you're also able to look at the witness and their demeanor and the way that they're answering the question. The other thing is that attorneys do have tools they can use during a deposition to help jog the memory of the witness. There are specific emails or documents that we may present to Secretary Clinton to see if that refreshes her recollection with respect to, you know, the subject matter. And a lot of times that's helpful, and you're able to still gather more information than you are for certain via interrogatories. And when you serve interrogatories, the written questions, depending on how the question is answered, you're not able to ask any follow-up questions, and that's key, and that's why depositions are just so much more useful.
Well, I forget the particular witness, but you were telling me there was a witness who, in the case that we had, one of the State Department officials who really didn't want to be terribly helpful to us in his testimony,
right.
Even when presented with an email saying exactly what he should have done or did. We were asked him, did it refresh his recollection? He said no.
No, so yeah, I believe, I mean, the transcripts are public. I believe, well, I'm not certain, but I believe it was Clarence Finney's testimony when I asked him, because to the state, so all we have to work with is the way that the State Department provided and produced the records that we asked for in this case. And there are a lot of redactions. And so, and then there are the communications that we're honing in on that have specifically to do with Secretary Clinton's email use and State Department officials discussing that back in 2013, well before a FOIA lawsuit was filed. And so my question to whether it was Mr. Finney or somebody else was, well, what did you review in preparation for your deposition? Well, I reviewed this document. Okay, did you see an unredacted or a redacted version? I only saw the redacted, meaning with the, you know, the information whited out. So in preparing for his deposition, he didn't even read his own emails. I mean, he looked at completely redacted form of the email. So my follow-up question was, well, do you think it would have been helpful for you in helping you remember if you would have actually been able to see what was in the email, and the answer was no, I don't think so.
Yeah, yeah. And the judge is going to draw his own conclusions
Correct.
from that type of testimony,
Correct.
assuming it's an important issue.
Correct.
So Mrs. Clinton will have to be deposed. Cheryl Mills will have to be deposed. These two State Department / former officials will have to be deposed. We'll have to get a subpoena out to Google.
Right.
And so what do we want out of this?
Well,
Generally speaking, I guess, because I think it's the one big thing is people should realize we still don't have all the emails.
well, that's my first thing, right? Let's go back to what we asked for. We asked for the communications about the talking points. So first, we need to have confidence that all potentially responsive records were searched and produced. So that's one of the things we want, right? The requests, the records that we requested. With the discovery of Secretary Clinton's email use, and for the first part to be done completely, and to meet its obligations under FOIA, you have to make sure you have all of Secretary Clinton's emails to search, right? To make sure that you have all the records that we asked for. And we don't have that confidence yet, so that's why we're doing this. So that's the first thing that we want out of this. The other thing is to know exactly what the State Department officials knew about her email use and when they knew it, because it's important in this case, which goes to the bad faith question. But look, these State Department officials are in front of the same court and this judge. How many times, and how many cases did they have back in 2014, 2015? And the truth just needs to come out about the truthfulness and the candor that they had towards the court. So I think that's important.
The court found it already one of the most, was it the language, one of the gravest offenses?
Gravest offenses, I think, was
related to transparency law.
Yeah.
So you weren't interviewed for Hillary Clinton's Hulu documentary, were you?
No.
But she was on TV the last few days pushing this documentary.
All right.
And I noted the other day she called questions about this issue bogus.
Yeah. Well, I think, that's the way her response has been from the beginning. Remember when she took out the cloth? What do you mean, wipe the server clean, like with a cloth? And if that's the seriousness that she still lacks with her understanding about Freedom of Information Act and the fact that she was the head of the agency. And that's part of the reason we want to ask her, what does she understand her obligations to be under FOIA, right?
Was that bogus too?
Right. There's a reason that we have the Freedom of Information Act. It's the public's right to know. This goes back to the Nixon era, right? And that's the reason that Congress enacted this law. And about a year ago, Congress amended and improved this law. It's important that the public have access to information as to what its public officials are doing.
So the testimony has to take place by May 16th. And barring unforeseen circumstances, people will be able to access the testimony. And so I just want to make it clear to those of you who are supporters, I want to thank you. And of course, I get to talk about all the great work Ramona does and our other attorneys do. So, this work doesn't just, we just don't get a court ruling out of the blue. It's years of litigation, and this has been 6 years of litigation. We knew something was up with Mrs. Clinton based on, in terms of her conduct at the State Department, just based on prior history, so we went back a long ways. But this is a significant measure of accountability because Mrs. Clinton never really has been questioned on the issues we're here, that we're going to be questioning her about.
Right, not under oath. Obviously she was interviewed by the FBI, but she had Cheryl Mills, I believe, who sat in as her attorney and also a fact witness in the FBI's investigation.
And Congress didn't really ask her about this either. In fact, if they had, we'd be unlikely to be able to question her because the testimony would already be out there.
Right.
So, well, thank you for your great work on this, Ramona, and I know all of our supporters will be rooting you on as and your colleagues as you prepare for Mrs. Clinton's deposition and Ms. Mills's deposition and getting that Google subpoena out. And I would like to thank all of our supporters for supporting our good work here, because you can see that our heavy lifting is getting some significant results on behalf of the rule of law and accountability. Thank you, and I'll see you next time.